Welcome back to Lost Channel. My name is Anton Vieltsin. I'm an attorney in the Southern District of California here in San Diego. I'm actually licensed in California, Nevada, and I take cases throughout the West Coast. Let's start with the basics. The Fourth Amendment protects you against unreasonable searches and seizures, meaning that if officers conduct a search without a warrant, that search will be per se unreasonable. But of course there are exceptions to the rule. Search incident to arrest, automobile exception, exigent circumstances, and so on. I've discussed many of these exceptions on this channel, and today we're going to look at a variant of one of those exceptions, which is called single purpose container exception. And before we discuss it, let me first thank you for watching me on YouTube. Please give this video a thumbs up and subscribe to my channel. And if you're listening to the audio recording on Spotify or Audible, please give my podcast a 5-star review rating. Let me catch my breath and I'll join you after this short break.
Hello, this is a prepaid collect call from
Lost Law Firm
at Western Region, San Diego. To accept this call, press 5. To refuse this call, hang up now. Thank you for using T-Netics. You may start the conversation now.
Let's discuss the Ninth Circuit case United States v. Gust, where officers received a non-emergency call from an individual who observed others shooting firearms on private property. That property, however, was located near a no-shooting zone. 2 officers were dispatched to the location. When they arrived, they heard gunshots. So they entered the property and they observed Gust and his companions walking away with what looked like firearm cases. The officers detained Gust and his companions, did a records check to see if there are any outstanding warrants. And during this detention, Mr. Gust told the officers that he was just practice target shooting and that inside those cases there were firearms. The officers then conducted a warrantless search by opening up the cases and finding a sawed-off firearm, a shotgun, inside the case, which was also unregistered. So Mr. Gust was charged with a federal offense possessing a firearm that's not registered. He argues that because there was no warrant, this was an illegal search in violation of the Fourth Amendment. The government relies on what's called a single-purpose container exception. Now, you might be asking yourself, Anton, how come you're not discussing consent or other exceptions that might apply in this case? In fact, I often receive comments after I publish these videos or on my podcast from people telling me that I failed to discuss some exception that clearly applies. Remember, I didn't forget anything. When I discuss these cases, I focus on what the court says. So often enough, another exception might in fact apply. However, if the court doesn't discuss it, I don't talk about it on this channel. So here, there might be an exception, consent, but we know that by the time this case gets to the Ninth Circuit, the government no longer relies on consent and doesn't discuss it, doesn't push for it, and so the court doesn't talk about it. So we're focusing on only one exception, single-purpose container exception. This exception originated with the Supreme Court case Arkansas versus Sanders, which was later overturned by the Supreme Court case Acevedo. Remember, I've discussed Acevedo on this channel before. It deals with the automobile exception, that officers can search the vehicle if they have probable cause to believe that incriminating evidence will be found inside the vehicle. But they can also search any containers within that vehicle. But here, Acevedo doesn't apply. Why? Well, we're not dealing with an automobile. We're dealing with officers arriving on the property and finding these containers, namely the firearm cases. So Sanders still applies, and it defines what's called a single-purpose container exception. And the court in Sanders explained it in this way. not all containers and packages found by the police during the course of a search will deserve the full protection of the Fourth Amendment. Thus, some containers, for example, a kit of burglary tools or a gun case, by their very nature cannot support any reasonable expectation of privacy, because their contents can be inferred from their outward appearance. This is nothing more than a variant on a plain view doctrine. Remember the plain view doctrine? It tells us that the officers can see incriminating evidence as long as they're standing at a lawful vantage point, and if that evidence is incriminating, this is not a search. What are we talking about? We're talking about police officers standing outside of your house and looking into the window like any other person could who's not a police officer. Of course, they have to be standing from a vantage point that's lawful. Or for example, if they find a jar that they can see through and inside they can see narcotics. Again, if they're holding this container from a vantage that's lawful, they of course can look inside because anyone else could do it as well. Well, here, why am I saying this is a variation of plain view doctrine? Well, because a single purpose container exception says that when we look at these containers, the only thing inside that could be found is incriminating. It belongs to some crime, and in this case, possession of a firearm. But here's the next question. When we look at this exception, do we have to look at it from a reasonable person objective point of view, or the subjective point of view of a police officer who's trained perhaps to look at these containers and see them as nothing more as firearm cases? Well, here's what the court says in Gust. The Ninth Circuit tells us that we have to look at this from the objective point of view of a reasonable person. And a reasonable person can look at these containers as a firearm container, but perhaps can also hold a guitar or some other musical instrument, because these cases are multi-purpose. And so the Ninth Circuit agrees with the defendant, Mr. Gust, that officers did in fact conduct a warrantless search in violation of the Fourth Amendment, because the single purpose container exception doesn't apply. You can't tell by looking at this container that the only thing it could contain is a firearm. It could contain other items. And so the case is remanded back to the lower court, to the district court, with the instruction that the evidence should have been suppressed because it was found in violation of the Fourth Amendment. If you enjoyed this video, please click like, subscribe, hit that bell notification button so next time I post on YouTube, you'll be first to know. And if you're listening on Audible or Spotify to my podcast, of course you can find it by looking for Law Stash on any of those places. Thank you for watching.